Everyone, welcome back to the ABA Compliance and Legal Series. Today's conversation is about something most ABA operators don't think about until it becomes urgent: payment scrutiny. Not audits after the fact, not damage control, but how a clinic operates every single day under the reality that payers are constantly evaluating patterns, documentation alignment, credential status, and internal controls. Payment risk in ABA rarely begins with an audit. It begins quietly in small operational decisions that drift over time. Our special guest today is Steven Antico, partner and director at Garfunkel Wild and chair of the firm's behavioral health practice group. Steve has decades of experience advising healthcare providers, navigating audits, investigations, and compliance exposure. Today, we're not walking through a checklist. We're talking about the real operational weak points in the field, where clinics believe they're strong and where payment risk actually hides. Steve, welcome, and thank you very much for joining us.
Steve, thank you very much. It's my pleasure to join you this morning. As we had discussed, again, Garfunkel Wild is a full-service law firm. We're basically the largest healthcare boutique firm in the country. We have offices in New York, New Jersey, Connecticut, Florida, and Washington, D.C. We have lawyers that also are licensed throughout the country. With respect to my practice, I'm a corporate and tax lawyer. So I have an LLM in tax. So I've been a business lawyer for most of my career. Approximately 20 years ago, there was a very prominent friend from Lakewood, New Jersey, that asked me to start representing his friends. His friends were single ABA providers that were being tortured by health plans. So I started working in that space, and it really became very fulfilling for me once I learned what ABA was and the need that it met in the community. So I started working with small providers, and then I started representing small providers that became big providers. So I will say this to anybody who's on this phone: I want to thank you all for doing the Lord's work, which are ABA services, because essentially you're helping kiddos, you're helping families, and you're helping the community and society address a condition that, frankly, is one that needs a lot of attention and also needs a lot of reimbursement. So the purpose of today's webinar is to discuss topics related to audits and investigations, as well as corporate compliance plans in the ABA industry. So audits and investigations can start off with basically a few different approaches. The first is when a client receives a warrant. This is when a warrant is a court order that authorizes law enforcement to take specific actions, such as searching a location or seizing property. If law enforcement presents at a client's office and a warrant is delivered and presented, the recipient must in fact comply. I have had situations where there have been warrants, all right, candidly with my firm, and I'll get into our compliance group a little bit later, but we're comprised of former federal and state prosecutors. But we've had to deal with warrant situations on a real-time basis. And it's challenging.
Steve, can I interrupt you for a second?
Sure.
If you want to share your screen and use your slides, I think that would be very helpful.
Oh, you think? Okay.
Yeah.
I have to apologize to the audience. Let me get it.
Yeah, this wasn't planned, but I think that I'm seeing that it will be very helpful. Can we all see it?
That's perfect. Yes. Okay.
Okay. So you'll have to guide me when to turn the page.
Yeah. Okay. If you can go to this, probably about slide 7, please.
Is this what we're up to?
Yeah, that's
Great.
it. Perfect.
Okay, go ahead.
So as mentioned, the warrant is a court order that authorizes law enforcement to take specific action to permit searching a location or seizing property. A subpoena is a demand to produce documents or testify in a legal proceeding. Unlike a warrant, a subpoena does not grant immediate authority for the law enforcement personnel to enter your premises and seize documents. Administrative action is an agency action compelling the production of records and documents. So this is like a subpoena. It's basically just a request in a different form. And then last is an overpayment letter or determination correspondence. This is typically a letter from a managed care plan notifying you of an overpayment. Now, in any and all of these instances, I highly recommend that you consult with legal counsel with expertise in the space, because any time that you're confronted by an audit or investigation or even a warrant, this is something that many of you probably have no familiarity with. You are all operating great ABA agencies. You're not dealing with investigations and audits every day. And that's where you want to identify legal counsel to assist you as this situation arises. Now, one of the most important elements of the audit process, you'll see it at the top. It says controlling the message and limiting the noise. If in fact your team realizes, A, you're being investigated, B, there's an audit, et cetera, I know all of you have the best of intentions conducting your business, And you're going to need to convey to the individuals in your office that, hey, this is a matter of course. This is kind of like a course of action in any ABA business. And you want to basically limit their distraction. If you act confidently, if you act in a form and fashion where you're reducing the stress by just saying, hey, this is just a customary proceeding and we're going to manage it with the help of legal professionals. This way you're giving calm to everyone in your respective business. Tzvi, next slide.
Yeah, can I just ask you a question on that?
Sure, absolutely.
So when you are getting this subpoena or this warrant, why is that? Is that a sign that there's something wrong? Is it routine? Or is it AI picking up something in the data that's signaling something to the auditor?
That's a very good question. It's a matter of course. It is routine, I think, at this point. I'm seeing agencies across the spectrum, irrespective of the cultures that they serve, irrespective of the locations where they are. It just seems as if health plans are doing all that they can to kind of address ABA. ABA, as we all know, is basically a limited course of treatment. A typical ABA session can be anywhere, I mean, treatment plan could be anywhere from 12, perhaps to 36 months. Sometimes you have situations where you have kiddos that are receiving ABA services for extended periods of time. So the health plans want to know. And if they see that there's basically no improvement in this child, they're going to then wonder, okay, if there's no improvement in the child, we've approved the treatment plan. Are you meeting the constraints? Are you meeting the elements of the treatment plan? So oftentimes it can be a result of, as you say, AI. So it could be the overlay of certain factors that they characterize as troublesome or dubious. But B also is like the records that they get in. They may look at like the EMR, they may look at what has been the charges submitted and look at the submission and wonder if in fact all of the services that are being billed for are in fact being provided.
So they may look at clients or patients that are having extensive care. Is that what we're saying?
There has to be improvement. There also has to be session notes that frankly reflect the implementation of the treatment plan, the results of the treatment plan. If in fact there does not seem to be any improvement, or that the billings and the charges depart from, again, the information that they have, that then will warrant some form of letter or even some form of demand for repayment.
Okay.
Next slide. Okay. Knowing that your records pass muster and are complete. When you're dealing with these health plans, the most important elements of your business is you need to know that for each kiddo that you're serving, that you have an ASD diagnosis. Now, importantly, ASD diagnoses, okay, may also be durational. Some health plans require a reaffirmation of the diagnoses every 6 months, every 12 months. Now, as we embark upon this path together, my suggestion is that you as providers create a chart. And the chart is going to be this overlaying chart regarding all of your health plans, because you want to have a clear understanding when a diagnosis is necessary for that kid as part of Aetna, for that kiddo that's part of the Blue Cross or the Anthem payment model. You just want to stay ahead of that and keep parents informed of when they're going to need a new diagnosis. Now, I put like Aetna exclusion of CARS 2. Sometimes when you are also the diagnoses and the affirmation of the diagnoses, that family may have some sort of CARS 2, which is an assessment tool. You want to identify situations when you have health plans that are trying to exclude certain types of assessment tools. Now, I had an Aetna audit. It was a sizable one where they tried to exclude CARS 2 as an appropriate assessment tool. And I was able to let's say, deal with that situation because their own plan documents and plan requirements did not expressly exclude CARS 2. It basically just maybe identified some, but it was not an exclusive list. The next item, qualified providers. You must know what you can bill for, meaning the specific technicians that you can bill for. So in certain states, there may be a requirement, okay, or the Medicaid guidance may indicate that BT status can be billed for. But a health plan is not married to the Medicaid guidance if in fact they have a higher standard. So I had 2 audits where, what an ABA agency was doing was they were billing for BTs when the plan said, no, we will not reimburse for BTs, only RBTs. So again, you want to know which plans you can bill your BTs for, which plans you must bill RBTs for. Timeliness. You want your records to be basically contemporaneous. I really want for people to input their information into our EMR platform to ensure that their notes, their session notes, etc., are in fact maintained, are in fact compiled on a contemporaneous basis. I do not want any sort of technician kind of walking out the door and coming back 5 days later trying to create a session note. It's inconceivable. So you really want to have a process whereby you're encouraging your technicians, your BCBAs to basically input information on a real-time basis. The treatment plan. Now, the treatment plan, as you all know, contains assessments, results, goals, interventions, progress tracking. Your session notes should really reflect all of the treatment plan elements, or as many as you can. And the session notes need to include the patient name, date of birth, all of these relevant elements. The reason is because you want to meet the expectations of the health plan. So, like, for instance, if you're submitting notes that frankly do not have the patient names, and I've seen it, do not have the providers, do not have the start times, that's not supporting a best practice that facilitates your payment entitlement. You need to ensure that your EMR has these sorts of things so that ultimately, if indeed you're identified as part of an audit, that you have the capacity to defend such a claim against you. Now, as I mentioned before about specific plan requirements, you really want to know if you're billing 7 different plans, you need to know what are the specific requirements regarding, let's just say again, assessments, updating your diagnoses, the treatment plan, the documentation, who can provide the service, BTs, RBTs. If you have that in front of you, it is a best business practice, and I think will serve you well. This way, you don't have to rely on memory. Okay, for Aetna, we have to bill RBTs. For United Healthcare, we're permitted to bill BTs. It's this sort of thing that if you are operating your business efficiently, this is going to be one of the underpinnings of your business. The next slide, Tzvi.
Yeah, quick
Sorry, go
question.
ahead.
This seems to me like ABC. Now, I understand that not all the ABA clinics are doing things like this, are doing this according to the book. But is this not built in the EMR that forces them to do this? Why, how can you drift over here? It's like pretty concrete what needs to be done and what shouldn't be done.
That's a very good question again. It should be built into the EMR. Now, on audit, I have had ABA providers submit, okay, their EMR to demonstrate their authority to bill. But unfortunately, what was submitted lacked relevant information. It lacked, for instance, like whether it was patient names or the qualifications of the RBTs and things like that. So you really want to ensure that it could be merely a keystroke because what is submitted may not be entirely representative of what's necessary for that plan. So you want to know that your EMR platform has the capacity to basically populate all the relevant information for the appropriateness and the capacity to bill. You want to ensure that it's in your record. So you have to look at your EMR to ensure that everything that you need to bill is in fact reflected.
So would you say that the EMR is actually a wonderful way to Q&A your system and your billing by just making sure your EMR is set up the right way? Would that solve many of the problems that you're seeing?
It creates such a strong platform, and also it's an electronic platform. Tzvi, I'll say to you, I still have to deal with people with paper records. It's painful. When you have EMR, it's there, it's organized, it's one keystroke, and you have everything that you need. And again, I'm not trying to marginalize what was the past, but the future is EMR and electronic because it makes the information available on a real-time basis rather than to have to start to allocate personal time and effort to accumulating all these records. So the
Right.
EMR can be it's a best practice to ensure that you are in fact complying with the health plan requirements.
Right. What I understand is that not all the EMR companies want to handcuff their clients because they want to make it easy for them. And in that way, they're doing them a huge disservice because in order to make it strong, where you need required fields, which should be the default, that would mean the ABA coming along and actually reprogramming it the way that it's compliant.
Correct. And again, each of the plans, I would say most of the plans are relatively consistent with the information that they're seeking. So I think that if you want to optimize your strategy, your business strategy, you want to really understand your EMR. You want to ensure that all the relevant fields are fully populated, that you can produce a record regarding a session or the entire treatment plan for that specific kiddo. Okay?
Okay, great.
Okay. Common billing errors and cues to avoid them. We spoke about provider credentials, right? So in that respect, each plan may have certain requirements for who can bill. Now, importantly, you may also have to avail yourself of specific modifiers of that plan. One health plan that we were working with in connection with an audit, it had this dual track for BTs. It said if the BT has less than a bachelor's degree, then it was one modifier. If they had a bachelor's degree, it was another modifier. So you're going to have to understand the relevance of your provider credentials and also the billing necessity to ensure that you've adequately characterized who is providing the service. We've spoken at length regarding the EMR output, make sure that any records submitted contain the minimum plan requirements. The next one that's also very interesting is I've had two audits over the last 10 years where ABA agency got flagged by a managed Medicaid plan, where there were family members that were employed by that agency. Those family members had kiddos that were receiving ABA services. Two different health plans, and I defeated both of them. Two different health plans basically were asking for recovery in excess of 7 figures because they said they were trying to take back all the dollars that were attributable to their payments over a period of time because I had a BCBA whose child was being treated by another BCBA, an RBT that she had no supervision over. Because of that, the health plan said, oh my goodness, we've matched the name, okay, the name of the kiddo to the provider, and we're basically, this is our recoupment effort. We went back and looked at the Medicaid guidance as well as that specific plan's guidance, and it did not indicate. I think they were overreading what they were asserting as part of the investigation and the audit. And we basically prepared letters in each instance, and we never heard from the health plans again. And it's been more than 5 years on each. So
What
when
was
you
the
have,
issue? What were they claiming was not proper?
they were saying that if a family member is like on a clinical team where a kiddo is receiving service, they were saying that then invalidates, okay, their respective obligation to pay, meaning, or the right to bill, it invalidates the right to bill. And they were basically asserting that all the services that agency provided, I think it was in connection with that kiddo, were basically being, at that point, there was a demand for repayment. So if you have family members that are part of your clinical delivery team and they have children who are receiving care as part of your ABA agency, I would suggest that you take a look at your plan guidance to ensure that is in fact permissible, that you're not going to have to deal with this, what I call ridiculousness later on.
What's
Okay.
the core issue that bothers the payer about having a child? If I have a clinic and I'm happy with my work and somebody has a child, they have their own child, why would they send them out? Why would they not send them to a BCBA that they trust and know?
I agree with your logic, Svi, but when you're dealing with health plans whose primary goal seemingly is recoupment and demanding repayment, they come up with very interesting strategies. And this is one where I thought that they just misread the guidance that they purported that gave them the authority to seek the refund. And we basically went through painstakingly Medicaid as well as state Medicaid and also the plan documents themselves. So that was ultimately how we wound up defeating it.
And you found that there was no such rule like that? Is that what happened?
We found that we said that you've misinterpreted the rule. Because of your misinterpretation, at this point, we are not acknowledging or acquiescing to your demand. And after that, in both instances, did not hear back. And sometimes, again, you don't want to necessarily wake a sleeping bear. But at this point, years have gone by. Client was very happy with the outcome. And that's what anybody in this instance wants to do. Whatever you can do to protect an ABA provider, you do. Because again, they're doing the Lord's work. And frankly, whatever I can do, I will do. Because, and just as a side story, there comes a time when I represent clients, I call it an action plan. But if you go down a road with a client and you really torture them, based upon my background, and I mentioned it to you, as a former captain in the Marine Corps, at times I call them battle plans. Because I'm not here to burn down a health plan's house, but I'll say this, I will make it very difficult to be very direct. I demonstrate a spirit of collaboration, and you have to, when you're dealing with an audit or an investigation, you demonstrate a spirit of collaboration. You also have to demonstrate that you've been there before. And that's frankly what anybody in this situation needs to do. You're not here to basically attack them. You're here to indicate we're going to work with you. But when you step outside the lines, when you're wrong, we will tell you. Okay? So the next item is telehealth. Now, the telehealth, if in fact you're billing telehealth on a telehealth basis, there may also be modifiers for the video conferencing. So you just want to be mindful of that in connection with the plan that they may have a telehealth modifier requirement. All right. So next slide, please. Okay. So where are you providing your ABA services? Now, when I work with agencies, I ask them very upfront, very quickly, because I want to understand their business. And this is more from a business understanding. So some of my larger clients, which are in numerous states, some of them are what I call BCBA models, others are BT models. So based upon the reimbursement, they're going to go to different states based upon what the health plans pay in those states, meaning what side are they weighing on? Is it a BCBA or is it the BT? Because again, the models can in fact differ. Now, I also ask, are you home-based or are you clinic-based? So the home-based, if in fact you are a client, I guess, providers entering the home, you also have an HR requirement here. You need to find out, are there any risks in that home, such as pets or individuals that may pose a risk? Ensuring that your therapists have protection and also have clear guidance with families in connection with family interaction during the treatment or even emergency protocols. If in fact there's an emergency that happens in the house, who is responsible for that child, getting that child to a safe and well place? So there needs to be some delineation of that just to ensure there's no confusion, but also you want to educate and create some standards and policies for your BT or RBT that's in that home to ensure that there's not a lot of meddling from parents. So there might be a time that she's available to speak to parents, but it's not during the treatment plan itself. So these rules and these kind of standards need to be implemented. The next one, which is a clinic-based environment. Now, the clinic-based environment is, I see, that can be an optimal setting. I do see, and I also work in my business as a corporate and tax lawyer. I also work with private equity companies, but not in the ABA space. I work with them rolling up different service lines, podiatry, musculoskeletal. I've rolled up urology. I've also rolled up oncology and multi-specialty. But in the ABA space, one of the ways that it can be optimizing revenue is having a clinic-based environment, because there you don't have that clinician driving from home to home. You basically have parents that are bringing those kiddos to the clinic. Now, more recently, I've had two different instances where an ABA provider has been identified by, in New York, it's the Office of Children and Family Services, and then there was another state where there was a claim and allegation that because the children were dropped off, parents were not staying, session times were in excess of an allotted hour amount, that you had different authorities characterizing an ABA clinic environment as a daycare center. Now, I also work collaboratively with CASP. I presented on CASP's behalf, and I have a very strong relationship with Lori Unum. And this is one where CASP has also weighed in on this to clearly indicate that ABA is not childcare and childcare is not ABA. So I just want to mention to you, if you're going to different states, you do at least want to avail yourself as, are there daycare or childcare center program requirements that you may trigger based upon your clinic model. The last piece of this is school, okay? Managed care organizations typically do not cover for ABA services provided in a school setting. However, we all know that there's benefits to providing ABA in a school setting as part of a pull-out program. In this case, in order to render services in a school, there's basically, I see two ways to do it. One is you need to demonstrate to the health plan that as part of your treatment plan that you want to go into the school to help that child assimilate. So it could be including as part of your treatment plan, getting that child from the home and driving them, okay? And the reason why I say you want to elaborate that in your treatment plan is to keep informed the health plan that, because again, when you're driving, that's an active responsibility. You are then passively providing ABA services to the kiddo in the backseat of the car. So you want to have that qualified as part of your treatment plan. Conversely, what you can also do is potentially rent space from the school. So you build for a 7-hour block. So this child did not need to use the bathroom. This child did not need to eat. This child had no nap time. And that's when I have to turn to my ABA provider and said, what are we doing here? If you've got to break down your billing in order to demonstrate that there are breaks during the day, I encourage you to do it. Because again, the typical kiddo on the spectrum, they're not able to sit for 6 to 7 hours without any of these. So I just ask,
none of us can, right?
yeah, you're absolutely right, my friend. You have some gray in your temples, as do I. So I know I could not sit there for 6 hours. All right. Exactly. And also, are you billing for transportation, yet it's not part of the treatment plan? This is one you really have to. If you're going to bill, if any part of the service is for transportation, you really want to elaborate that, because if it's determined as part of some sort of audit or investigation process, it's tough to defend. I just want to mention, when I deal with health plans and I go into battle, you have to try to give anybody who's working with you a good record to defend. Okay? Next up, Steve.
Is this one of those things that they can extrapolate and decide that if we found a few records that we're not taking into account nap time or break time, so we're just going to take off 20% off of every bill that you've submitted?
It becomes a little bit more than that. Before you know it, it's probably they're not going to overlay a 20% methodology. If they're oftentimes, and again, it gets into what I call an extrapolation. If they say, if we're assuming that you're doing this for this one, you're admittedly doing it for everybody. So that's an extrapolation. And if you give me like an extrapolation like that, if I can defeat one element, I can defeat the entire extrapolation. Okay. So if you are doing this, it makes it easy. It does. And that's why I say you got to look at it the way a regulator would look at it, and look at it through their eyes. What is defensible? And your treatment plans and the services that you render, if transportation is not part of the treatment plan and you're billing that, remember, driving is an active responsibility, all right? And it's an active verb. But you can only be passive at that time providing ABA services because you're focusing on driving. And that's where, even during the breaks and the nap times, things like that, if you're continuing to bill, you're not providing ABA services during that time. And health plans want to be assured that you're not. And if your records do not assure them, then they're going to basically be seeking potentially the recovery of everything that they've paid to you in connection with that kiddo.
Right.
Next slide, please. Okay. These are overlapping service codes. This is like a little bit more technical. So in essence, I'm going to go through these relatively quickly. 97153 and 155. All right, they are basically different codes for very similar services. But if you've got two of these respective codes, you basically are like billing on a duplicative basis. And it happens. Sometimes you may have like the BT responsible for one thing and the BCBA responsible for another. Your EMR really needs to indicate, okay, 9 to 11, it was the BT, 11 to 1, it was the BCBA. If it doesn't do it, then the health plan is going to be like, how do we know? You have to demonstrate to us that you're not providing services by these two people on contemporaneous basis, because we're not going to permit you to bill for that. So that's why you need to have your EMR clearly indicating 9 to 11 is BT, 11 to 1 is BCBA.
Are there no health plans that allow simultaneous billing if you can demonstrate that each one was performing a different role?
It's unlikely. It's going to be unlikely, because when you look at it, each has a goal as part of the services. And you're dealing with a kiddo who could be 3, 4 years old, et cetera. It's rare that I see that you're going to have both of these bill or provide service at the same time, because ABA is typically one-on-one. It's not multiple on one, because you're dealing with somebody with a limited capacity to embrace what it is you're trying to do. And that's why I say ABA is one-on-one. It's not multiple on one.
You can
Okay.
have a BCBA analyzing the session and understanding how the kid is doing and altering the treatment plan based on that.
But you see, the BCBA they can monitor a session, but a BCBA is different from a BT, because the BCBA is basically in charge of the treatment plan and its implementation. So that's going to be a different code. But a BT and a BT and a RBT are typically billing for the same service. The BCBA, they're going to be providing their services kind of like in an overarching way, where it might just be for, let's just say, for an hour, or maybe it might not even be that. It might be like much shorter, because again, they're not usually going to be supervising for the entire period. They're basically going to be supervising for a limited portion of the period to ensure that, again, elements of the treatment plan are in fact being implemented, and they're basically being reflected in session notes.
Right.
The next one, which is the CPT codes, all right? So this is one also can get a little confusing. So 156 and 157, that's family training. If in fact again, it's kind of, is it being done on an individualized basis, or is there like a group environment for the same session? So that can also be troublesome. The other elements, the 97153 and the HCPCS 2019 codes, those are different services themselves. And sometimes when you have, again, a BT in a room and somebody like an OT, okay, or a slip, it gets a little bit dicey, because a health plan sometimes will look at it and say, wait a minute, you've got these competing protocols that are working with this kid. I do believe that you can have a BT and a slip work collaboratively, but again, you just basically have to clearly delineate what is happening as part of the treatment plan. You want to indicate that there's this concurrent process. Next slide. Okay, so a number of these items we've indicated or already addressed. So denied claims. This is when the documentation means that records are missing or incomplete. Some payers will indicate what's missing from the record. Most will not. In that regard, my suggestion is basically you can kind of compile and complete a claim-specific medical record review for the claims that have been brought to your attention. All right, the incorrect billing codes, again, that's when we use the wrong billing codes, you mismatch service modifiers. So that's also, again, you want to have a periodic review and assessment of the codes that you're billing. There are not so many, so it should be relatively easy to do. Again, you just want to be sensitive to your codes, and even your EMR platforms now are also quite good about keeping people in their lane, because again, some of them are perhaps more advanced and identify when incongruities exist. Okay, records not provided, that's again relatively self-explanatory. Going to the authorization issues. As I mentioned before about the pre-authorization issues concerning the assessment, you want to ensure that your assessments are done on a timely basis and also reinitiated to ensure that you're meeting the plan requirements. And the provider credentialing, this is one, you have to get your providers credentialed. If a therapist is not presently credentialed with a plan, that they can easily refute the billing that you're seeking. So you have to ensure that your therapists are in fact properly credentialed. And again, it doesn't take too long, but it just needs to happen. And you just need to basically exert attention to it. Next slide, please.
Would you be able to throw out a ballpark figure of what percentage of claims are denied and what percentage a good ABA company should consider pass rate, like 95% or 90 or?
It should be upwards of that. I would think most claims, I'd say most ABA agencies are doing it correctly. They're doing their best, all right? They're paying a lot of attention to their records. They're paying a lot of attention to complying with the health plan rules. I would say it's tough to really quantify the percentage, but I would say most of our health plans, again, I'm not really, I mean, most of our ABA providers, I'm dealing with audits usually on a random basis. Now, I have a lot of clients in the ABA space, so I might hear from this one in New York who's dealing with Fidelis. I might hear from this one in New Jersey. I might hear from this one in Florida. I might hear this one in another state dealing with one of the blues. So it usually gets back to the documentation, the record keeping, what was submitted, what are they refuting. Some of the health plans will turn over their records to indicate this is what we see. Those, to me, are very collaborative plans. They're trying to say, this is what we see. These are the incongruities that exist. So that's a help. We got some health plans that basically say, okay, these patients, we requested records. The information provided does not support billing. What does that mean? What part? Can you be a little bit more elaborative? So the long and short of it is, many of the people on this call may not experience an audit in the next 3 years. If they do, again, just get to the heart of the matter and try to discern what it is the plan is looking at to the best of your ability and request as much information as you can. Again, when I deal with health plans, I work collaboratively. I'm not here to burn down their house because I know I have to demonstrate to them that we have been compliant and that our record keeping has been good. And sometimes, again, they listen. They're like, okay, we understand. And again, they've already commenced like prepayment review, so I'm able to kill two birds with one stone by just demonstrating that this client is committed to compliance and the proper submission of charges for services rendered. Okay, so next slide. Okay, so we've addressed these already. With the service discrepancies, home, office, school. I would like to maybe just get to maybe the next slide because I think it's important. Okay. So these are things that you might hear from different health plans, okay? You might hear that they want to put you on a performance improvement plan. All right, this means that the provider has been identified as needing to improve certain aspects of their practice, whether it's quality, patient outcomes, et cetera. This is not a bad thing. This is basically an educational format where they're looking to work with you to help you improve in order to help meet the needs of their beneficiaries. The prepayment review usually is the second step in connection with an audit and investigation. So when you're put on prepayment review, I think each of you knows that your respective claims are going to be reviewed before payment is processed. Now, this can result in cash flow delays because, again, if you're submitting your plans, you're continuing to basically provide services and you're updating your plans continuously. But a lot of the people with these plans are overworked and underpaid. So they'll get to it when they get to it. When I'm working with them, if I can defeat their claims in connection with the investigation, I can often end the prepayment review process if we can, again, deal with them regarding the initial claims and allegations. Okay?
Can I ask you a question that's come up in the Q&A?
Sure.
When a BCBA is watching, supervising a session, the 5% or whatever the health plan requires, can the BCBA charge time for that?
Well, the BCBA, as part of their, again, that would be 97, let's see, I think it's 97155. You can, again, I think the BCBA is basically billing for their overriding service. Okay. So if they're supervising that respective session, if the plan permits it, you can bill it. If it's not, well, you have to commit that time and that resource to it. But later on, when that BCBA can ultimately update the chart, update like where they are as part of the treatment plan for purposes of documentation and compliance, that can be billed.
So it wouldn't be the actual supervision time, but it would be the updating of their records after the session. They're taking of their findings and creating, adding to the record.
Each plan can differ. So you just want to be mindful of what does that plan permit. And it's usually going to clearly indicate in the participation rules as to what you can bill for the services that are provided by your agency.
Okay.
Okay. So the adoption of the compliance plan is a set of policies, guidelines, and procedures that a company establishes to ensure that its employees and agents comply with laws, regulations, industry standards, and the company's policies. Now, this is important because sometimes with different health plans, they may request a copy of the compliance plan. And the reason that they're doing it is because they want to see, are there rules in place? Is there guidance internally to educate people regarding permissible services rendered, or how the services are rendered, et cetera. So you want to have a compliance plan because, again, it demonstrates your commitment to compliance, which is quite important. Now, in certain states, it's a legal requirement. Okay, for instance, like New York requires in two instances. One, if you're in Article 28, the other is if you're billing a Medicaid on an aggregated basis for more than $1 million, including Medicaid HMOs. So if in fact you're receiving $1 million or more, a compliance plan is necessary. Other states, it's not, but we would characterize that then as basically a best business practice in order to ensure that you have demonstrated to your team, you have demonstrated to your employees, agents, and representatives that you are taking compliance very seriously. Okay.
So when you say
Next,
compliance plan, do you mean clinically or administratively? What kind of plan are we referring to?
No, administratively, because what you're trying to do is you're trying to establish a course of conduct and guidelines internally to basically educate people who are associated with your agency as to what is permissible, as to what our company stands for. It's just basically creating rules and policies that frankly are intended to guide all the representatives and agents of that business to ensure that they're conducting themselves in accordance with applicable law and industry standards. So some may characterize it as like words on a page, meaning they may get a compliance plan and never properly implement it, never properly educate their team about it. And that we feel is it's a disservice because ABA is under the microscope. Other service lines are under the microscope. So if your team, if your providers are in fact educated about what is compliance with applicable law, what is compliance initiatives regarding record keeping and client management, it just creates the foundation, the framework from which we or anybody in this instance can demonstrate to a health plan that compliance initiatives have been identified and are embraced by our company.
So I guess that means that this is not drilled down to the level where it would differ from plan to plan.
It won't. It's an encompassing set of rules and internal guidelines to ensure that our company and our employees, representatives, and agents are fully informed about our compliance initiatives. So a compliance plan, as I mentioned, and it's the next slide, Tzvi, all right? A compliance plan is comprised, again, of a code of conduct. And these are general standards of conduct which affect all the individuals associated with the company. So these standards basically build in what are called like the anti-kickback rules, okay? Also civil monetary penalty law. So what it essentially does is it educates everyone as to what's permissible from a health compliance perspective. You want to know that, again, the associates and the employees are not receiving payments from beneficiaries. You want to ensure that they are, like, if in fact they see something that's wrong, you want to create basically a standard that they can report it to the compliance committee or the compliance officer that they're seeing something that's wrong or incorrect. So you're creating a pathway for them to report on an anonymous, confidential basis situations that they have seen. And you want to encourage these people to come forth. When you have, like, for instance, we also periodically, I'm dealing with kind of what are called key TAM actions. Key TAM actions are basically when you have what's called a relator, which is a person who has seen impermissible and unlawful practices that are basically being reimbursed by a federal agency. It could be Department of Defense, it could be Department of Health and Human Services, which is Medicaid. So it could be different agencies. But again, the key TAM and relator actions allow private individuals to basically identify wrongdoing. But if you have a compliance plan, you're encouraging these people to come forth. You're basically saying, hey, if you see anything that's wrong with our structure, our operations, report it internally because we're going to deal with it. We take these issues very seriously and we're going to manage them effectively. So that's basically a necessity for a corporate compliance plan. And the next slide details the elements to a compliance plan. So a compliance plan is comprised of written policies, procedures, and standards of conduct, the designation of a compliance officer or a compliance committee, and also importantly, having a compliance training program and education process. I would presume that each of the agencies are going to have compliance program training. They're going to also have harassment training, which is also of critical importance. On a periodic basis, educating your staff is important because it demonstrates who you are and your commitment to compliance. Now, before I mention like the lines of communication, this is where patients and staff can report actual or suspected compliance concerns. So again, there needs to be the framework. People need to understand that, hey, we as a company are receptive. We as a company embrace the opportunity to do things better and to do things in a compliant fashion. And we ask that you come forward. Now, there may be times when a situation arises where you have people that are stepping outside the compliance plan lines. This is, if such an instance, this is when you're going to have your compliance team and your HR team basically educate employees or ensure that they're aware of the obligations. And if they run afoul, the employees then can be disciplined. So in such an instance, you can have like employees that are basically violating their respective professional duty to you. You can use your compliance plan or breach thereof as a means to basically implement some sort of disciplinary plan. Auditing and monitoring, these are areas that, again, I would suggest like you look at your records and your documentation to just on a periodic basis or across the board for different health plans to ensure that you are billing on a compliant basis. And then as complaints or allegations are made, you want to deal with them on a prompt and efficient basis, meaning you don't want a month or 2 months to go by because then somebody's going to feel like their claims are just being ignored. No, you want to take these things seriously. You want to address them promptly. And you want to basically demonstrate to your employees and representatives that your company is a compliant company and you take all compliance initiatives seriously and want to address them accordingly. So that's essentially, I guess, what I do and how I deal with my different ABA practices and service lines. Again, this is a space that I think it takes special people to want to provide these services and conduct these businesses. And also what I try to do is I try to provide a framework for growth strategies too, because if you're able to do it in a couple of locations, you never know if you can build a more encompassing methodology to basically build a model that may attract the attention of private interests. Because again, there's sometimes transactions that are private equity sponsored transactions where ABA and similar service lines are rolled up and monetized. All these things, I guess, go into then a lot of the analysis and the elements of the operation of an ABA agency. So, Tzvi, thank you so very much for inviting me, and hopefully your team and the attendees found it informative.
Yeah, as an attendee, I can say, in representing them, I can say they definitely have. Just, I think to sum it all up, I think that we've learned today that payment stability in ABA isn't about reacting well when something goes wrong. It's about operating intentionally, aligning documentation, and leadership oversight in a way that actually holds up under scrutiny. Correct. Just a word about NUCO filings. At NUCO, we handle entity formation, registered agent service, and ongoing compliance nationwide. We serve ABA operators across the country, and conversations like this is how we make sure we're supporting our clients who work in complex, highly regulated industries, not just processing their filings. I've written a new book called Compliance is a System, how ABA clinics really control risk, revenue, and survival, which builds on many of the themes we discussed today. If you'd like more information about the book, feel free to reach out to me directly by email. And thank you for all our listeners. Stay tuned because we have more episodes coming in this ABA compliance and legal series. So thanks for joining us today, and I hope we'll see you again on our next episode. Thank you again, Steve.
And Tzvi, if you want to circulate my handout to the attendees, by all means, please do.
Okay, absolutely. If you would like the handouts, please just email me, and I'll be happy to send it to you, along with the recording of the episode. Thanks again, everybody. Thank you.
Thank you all. Stay safe and well. Bye now.